This is Reasonable Doubt with your hosts, Mark Garrigus and Adam Carolla.
Yeah, get it on. Got to get on the choice, but get on mandate. Get it on. Welcome to the best hour or so in the universe. It's Reasonable Doubt. And I'm Adam Carolla. It's Mark Garrigus over there.
Yeah, I'm in New York today, but for our listening and viewing audience, doesn't Adam clean up well? I mean, look at him. He can go. I was going to wear yesterday. Gary and I did the Beyond a Reasonable Doubt, and the vote here in the New York office is that I put on my Adidas sweatshirt as homage to you because you weren't there, so that I could channel you. And then today, look at you all dressed up like you're going to court, where I just came out of.
Yeah, well, I'm filming something, so lest anyone think I just did this for you guys or Mark or Gary or whomever, I think we've established that pattern already. What court were you just in?
I was just doing Tinhorn Flats, and His Honor, we had asked 2 weeks ago when the city of Burbank was trying to convert the temporary restraining order to a permanent injunction. And I said, look, Judge, I'm having talks, put this thing over for a couple of weeks. I think we can resolve this. If we've got reasonable minds here, I think we could make this work, because this really is the height. From my viewpoint, I don't even understand what the city of Burbank is doing, but I figured I could craft an exit strategy. So anyway, he continued it to today, which is Friday as we tape this. And neither of us filed anything. The city didn't, I didn't, because the judge had said, I don't want any more paperwork. And, understandably so, we've killed trees in this thing. But his first comment out of the box on the record was, doesn't look like we were very productive in the last 2 weeks towards a resolution. I said, boy, is that one of the great understatements, because and I'm going to move to dissolve the order. Funny that you ask a question, I go on my usual monologue, but I'm going to move to dissolve it. What they've done now, not only did the temporary restraining order never cover Lucas, the 20-year-old son, talk about visiting the sins of the father upon the son, but in addition to that, it did not restrict access to your own piece of property. A judge on a temporary restraining order, unless it's a domestic violence case or something like that, you can't tell somebody they can't use their property. You can't have access. And he specifically said that in the order. So City of Burbank, for those of you who are not in the weeds, they set up sandbags around the place. Then they brought in, I call it a SWAT team. It looks actually, I think, more properly like what the armed forces do in Fallujah, where they all hang on. Gary, do you have that picture of the?
I will in a moment.
Cops? I saw that you tweeted that picture. I've done these. I did a ride along day with the Hawthorne SWAT team, and at one point, we did that. You get in your full uniform, fatigues, and all suited up, and then you hang off the outside of a large kind of dually box truck with running boards and grab handles. Now, when you tweeted that, I didn't retweet it because I thought that was you making a joke.
As did virtually everybody else, saying that I took it from Portland. Everybody, the Twitter sphere, thought either they fell into one or two camps. Adam, who knows there you go. Adam, who knows me, who thought this can't be real for outdoor dining. And then a bunch of people who, real geniuses telling me fake news. That was in Portland. But then, Gary, did you see the second one I tweeted?
Yes, I did. I'll put it up right now.
So where did you get this picture?
They have I have somebody who was out there who took a video. I extracted it as a still shot from the video outside of Tinhorn Flats. This is what the city of Burbank is doing. I mean, it is almost laughable because it's such insanity.
Yeah, it is.
There you go. So to all the people who thought it was Antifa, take a look at the patrol car. That's Burbank PD. Not only do we have the invasion of Fallujah, we've got the armed Burbank escort as well.
Wow. I'm rarely at a loss for words, but I am really at a loss for words. When you tweeted that picture, I was like, this is Mark being funny with some hyperbole and a wink and a nod. That is fucked up beyond, that is FUBAR. Fucked up beyond all recognition.
Let me just add a couple of other layers to this. They actually brought the city out and they sandbag around the entrances. They've sandbagged it, just like we're in Iraq during the invasion. And Lucas apparently trying to get to the patio to make sure that everything was copacetic as he's lifting one of the sandbags so that he can get through. What do? They arrest him, $5,000 bail. What? Mind you, a week after, the California Supreme Court just ruled cash bail when you're not a threat is unconstitutional and illegal. That didn't stop the city of Burbank.
Wow. And so why did they send the SWAT team? What were they doing?
This Constantine, whatever his name is, the eighth wonder of autism, has decided he's going to be he's going to be the Sheila Kuehl of Burbank. I mean, it's really what it is. You know, Sheila Kuehl was the one who voted to close down outdoor dining, then promptly ran out to Santa Monica to do outdoor dining.
Well, I know. And the excuse is always worse. Like, well, this was a place I always eat at. What do you think I do? I drive to Nevada to eat at strange restaurants? This is what everyone does, you crazy bitch. They go to the fucking place they want to eat at, and they eat there. That's how eating works.
But did you see day 2 of the Sheila Kuehl Alibi Ike tour? Day 2 was when they busted her. Then she came up with your excuse that you just said. Then she says, oh, I wanted to wish them well because I knew the impact my vote had on them.
Right.
Can you believe that bullshit?
And grab a tin of Stromboli before you left. Yeah. If you want to wish them, well, then just show up with a bouquet of flowers or a fruit basket. Right. Don't go fucking take food home.
Send them some cash, Sheila. Give them some cash. She
didn't even take it home. She dined outside.
Oh, she ate it there. Oh, yeah. Awesome. All right. Well, listen, everybody. Again, we don't blame Burbank. We don't blame Sheila. We don't blame Alexis or whatever stupid name is. These are Constantine. These are moronic imbeciles who should never be elected to any position, dog catcher or beyond. I blame us. I blame society. I blame the sheep. They sit by and they watch it. They just sit and watch it, scared to enter the fray, scared to get involved, scared to say a thing. God forbid I send a tweet or two out about the teachers' unions and they all jump on me. You pussies better fucking prioritize, because this is what happens when you just turn a blind eye to this overreach of government. These are civil liberties. You're watching them go right down the fucking drain, and your job is to get on Twitter and attack anyone who has thoughts about wearing a mask outside or schools reopening or outdoor dining. You pussies better start prioritizing. Thank you.
Well, it's interesting, and this can segue into Chauvin, because I feel the same way about that. If you don't understand if you are not a student of history, if you do not understand how societies unravel, if you don't understand how precious your rights are, it's always easy to start off by taking away rights when it's a person or a cause that you can denigrate. It's always easiest. You start off with the most horrific, vilified person, and you want to strip them of their rights. And everybody always says, oh, that's fine. And so one of the reasons that I've been I would say, on a soapbox about the Derek Chauvin trial is for precisely this same reason, for the reason you and I go crazy about COVID restrictions that make no sense. I'm now watching a criminal trial, and I've said this 100 times at least to you, Adam, that my practice is primarily suing police departments and policemen for excessive force, wrongful death, exceeding the scope, and fighting qualified immunity. That's been kind of my mission in the last 10 years. So I do not, these are not people that I embrace. I'm the opposite. I'm probably their poster child for somebody they'd like to see get run over.
Can I just jump in and say this to all the people that are listening? Please stop mistaking people who have sort of strong constitutional ideas for fans of fill in the blank. This is a big problem. You know, it's like, oh, you don't think COVID hurts people? My uncle is in the yeah, and I'm not saying that. I'm saying shutting a society down and locking people in their homes is not a good thing. It's not me cheerleading for COVID, and it's not Mark cheerleading for bad cops. We are defending a constitution and a process. It's like if you said no more smoking in your home, you have to go out and you have to climb a tree and go in your backyard. Well, I'm not into smoking. I'm not into defending smoking. I'm into the constitution of it. And you can't divide it into smokers and non-smokers. You know what I'm saying? Because you can't just be
exactly what you said.
80% of the society doesn't smoke. But you shouldn't be cheerleading an ordinance that says a guy can't smoke in his house.
And by the way, when I took logic in high school, one of the 10 most common fallacies, logical fallacy, is you attack the man, not the argument. Or in this case, you attack the pronoun, not the argument. So the idea that I have to always do this disclaimer and that you have to interpret it, what I'm trying to say, is somewhat frustrating, but I do it anyway to try to illustrate the point that if you make bad law with somebody you despise, there isn't an exception for that bad law that it only applies to bad people. It applies across the board. Interestingly, I saw something, somebody was asking me yesterday on a news interview, how they're getting a lot of this evidence in, something that you and I have been talking about, Adam. And I said yesterday to somebody, I don't practice in state court in Minnesota. I'm the first one to say that none of this, or a large portion of the evidence that is coming in makes absolutely no sense to me. And I found an article yesterday, Gary, I sent it to you, and there is a doctrine that apparently only exists in Minnesota. And Gary, it's called the Spark. What is it called? Spark
of Life. And it comes out of a 1985 case where somebody killed a Minnesota police officer. And the defendant argued that he was unjustly prejudiced against the jury when they introduced evidence talking about the police officer's family and his children and all the people that loved him. And the Supreme Court ruled that as long as it doesn't sway the jury, it is admissible to talk about the people in the community, the impact that this person had. So this is translating into the Chauvin case in that one of his brothers will be allowed to testify about how great a guy he was and the people that he left behind and that miss him.
Interesting.
And by the way, interestingly, Gary hit on the irony here, that the only reason, in my humble opinion, the Minnesota Supreme Court came up with this completely outside of the mainstream. Literally, it does not exist in any other area, in any other state nor federal. Can you have somebody get up and talk about somebody's spark of life in a guilt phase? But the reason that this is now a doctrine is because in 1985, The Supreme Court wanted to do it so that they could affirm a conviction involving a person of color who was convicted of shooting and killing a police officer. The irony here is rich. Now we're going to use it in reverse. I'm going to tell you that will be wielded by prosecutors. That doctrine has been and will be, if it's affirmed, in a way that people who don't have resources are going to regret in the worst way. All that does is tug at the heartstrings of the jury, like week one of Chauvin, which is, eat my feelings, basically. It has nothing to do with the elements of a criminal offense. It has nothing to do with determining guilt or innocence. It's basically trying to prejudice you more than having it be probative. And to me, it's an outrageous legal theory. The judge, by the way, yesterday, Adam, told the prosecutor.
Can we stop for 1 second? So first off, what Mark is describing is what he's worried about coming to fruition, and it already sort of had. This precedent of law that you think is noble because it's being used for this thing now then gets used against. I don't know. It's sort of like the filibuster. When that thing came back, the Democrats wanted it back, I believe, and then later on it got used against them. Be careful what tools you put in the toolbox, because it's you think you're going to use it against the other guy. At some point, it may go against your skull. Is basically what Mark said.
It's exactly right.
But can I say this? You said the provision was they couldn't, in Spark of Life, is that they couldn't have people, they could speak to what a kind and gentle soul the person was, but it couldn't affect the jury. But how could it not affect the jury? And then what other reason would you discuss it for?
That's my point. Why else are you going to use it? This judge is becoming fed up. And the problem is, I'm going to psychoanalyze this judge from afar. This guy thought, I'm going to, rightfully so, I'm going to televise this so the public can see it. Because of COVID, because of the interest, we're going to have this televised. I think in supersized trials, they probably should always. I've been arguing this. Biggest mistake I ever made in a couple of trials was not having it televised. However, this judge is becoming increasingly frustrated with what's happening in that courtroom. He actually lectured the prosecutor yesterday. If you put up his brother and start asking him or suggesting that Mr. Floyd is a gentle giant, these are his words, not mine.
Floyd's brother. Floyd's brother.
Yeah.
Yeah. Okay.
And if you describe Floyd if he describes Floyd as a gentle giant, you have now entered into the zone of character evidence. And if you enter the zone of character evidence, because this has been a raging debate in the criminal law for almost 30 years, what they often use as a signature of the crime is really just a backdoor to get into character assassination. Here, they're doing the flip. They're trying to get in this spark of life evidence as kind of good character. The judge has already previously ruled that a bunch of stuff about George Floyd is not going to come in. So for all of you who say don't try the victim, the judge was with you. The judge was not going to allow them to try the victim. However, the judge warned the prosecutors yesterday, you go down this road, you better be very careful, because if you make a misstep, I'm letting everything in. I'm letting stuff in that I previously said was not coming in.
Gary, who sent me a note, says he has a Spark of Life statute.
I wanted to read the exact wording here. The Minnesota Supreme Court ruled that such evidence is allowed as long as it does not invoke undue sympathy or inflame the jury's passions. And I just wanted to highlight that, because how do you measure that? That's insane.
Well, but I would also argue the only reason you're putting someone up to talk about a person's character is to make the jury feel one way or the other. Gary is now drunk with power. He has his new position as a co-star of this program and is chomping at the bit to get mic time. Did you notice that, Mark?
Yeah, I noticed. Well, did you notice yesterday the love Gary got on Twitter? Did you notice that?
I know.
From one Adam Carolla himself.
Starring Gary Patrick Smith. As an aside, occasionally he'll have guests Mark Garrigus and Adam Carolla.
Listen, what I did with you on Twitter by saying you did a great job and retweeting it was tantamount to the ex-husband showing up at the wedding of the wife who divorced him 4 years ago and going, I wish you too well. I wish you well. I wish you a lot of luck.
I'll take it.
That's what I did, essentially. What am I going to do? Knee you in the groin? I'm eating shrimp. I've had some cocktails. I wish you luck. You know I don't.
Were you in your $7 million mansion
I was
or your
in
$2
my
million
Malibu mansion? But
it was 7.3. Stop it. You're bringing down my property value. 7.3.
It's called a setup, Mark.
That's a setup. All right. So, a lot of stuff. Now, I was interested. Of course, I was listening to Beyond a Reasonable Doubt. I've heard some other commentators talk about Floyd's partner, driver, dealer, whatever we're calling this guy. And you guys,
what's his name? Gary Miller?
I think it's Morris Hall.
Morris Hall. So you guys went through the nuts and the bolts of it. And as I understand, the prosecution can waive everything and bring him on, but the defense can't, although the defense can.
Right. They're going to bring on people to talk about spark of life. But when it comes to a precipient witness, the prosecution's going to gameplay and not give immunity to this person. Why aren't they giving immunity to him? If they're just seeking the truth, why isn't the prosecution giving immunity? Explain that to me. What am I missing?
Well, is there a version of this? Well, first things first, it's interesting to me that the judge can't just say, hey, this guy's a key witness in this story. You must come and testify. I don't understand why the judge can't compel him to do that. The judge, there's a limited area. I've had this issue and gone to the ninth, in federally at least, gone to the Ninth Circuit and back. There's a limited issue under certain circumstances, which we don't have time to explain right now. But a judge can do it. But the judge he's basically wearing a legal straitjacket and has to, the number of hoops and hurdles and everything else and it makes it almost an impossible task. The prosecution can do it with the stroke of a pen. I mean, it's that easy. Would the judge allow, or is it admissible, for instance, so I'll give an example. You get pulled over, the cop suspects you've been drinking, he says, I want you to take a blood alcohol test, and you say no. So you don't take one. So then at some point, you get into court, and they go, I was sober. And then everyone goes, yeah, well, why wouldn't you take a breathalyzer then, right? So it kind of can be used against you, even if it was never used. Can the defense say, isn't it curious that the prosecution is not going to let this key witness, I mean, literally one of the people closest to the action, it's interesting that they're not going to let this man speak, or they won't compel him to speak. Can the defense sort of used my breathalyzer analogy? You'll never get the breathalyzer, but you do get the assumed guilt of not using it.
Let me break it down. In the breathalyzer example, you'll get a explanation or a jury instruction that talks about refusals and what that means and consequences. Here, it's a little more nuanced because you can comment on the other side not calling witnesses, that they've got the subpoena power, they can call any other witness. It gets more kind of thorny when it's the prosecution not calling a witness. Clearly, the defense can say they should have called. We know there was a witness there. Where is this witness? Blah, blah, blah. One of the things the defense may ask for, if the prosecution does not give immunity, the defense may ask the judge to give an instruction that says, this guy, we subpoenaed this guy, but he invoked and he won't testify. I've done that, and I've gotten judges to instruct that. It's very rare to put a witness up and have the witness invoke the fifth on the stand. Most jurisdictions, you can't do that and won't do that. Although I've had cases where I'm cross-examining the witness and all of a sudden the judge or the witness's lawyer will all of a sudden invoke the fifth. But you can comment. The prosecution has a little bit more dangerous territory to kind of survey. They cannot suggest that the defense has any obligation to present anything because contrary to what Twitter and most of the media reports, the defense has no burden whatsoever. The burden of proof is on the prosecution. You wouldn't know that by listening or reading any of the coverage, but the burden of proof is clearly on the prosecution. The defense doesn't have to prove anything. In fact, as I tell jurors when I'm selecting them, I can sit here in my chair next to Joe Dokes, who's my client. I do not have to ask a question. I don't have to even talk to them, to the jurors. I don't have to ask a question of the witness. I can sit here the entire time, play on my phone and check out my stock portfolio. And I don't have to do a thing. And I can get up at the end of the case and say, find my client not guilty. That I've never done that, but you can do that. And that's what the burden of proof is. Prosecution cannot shift that burden of proof. The public has already, and the media has shifted that burden of proof in this case.
So is the defense allowed to say, we would like to speak to Mr. Hall? He was there. He had by all means, he had a close or a relationship with Mr. Floyd, but they won't put him on trial or have him take the stand. We know not why, but so he may stay where he is now, which is in prison for unrelated crimes. I mean, I did this once that I can remember, maybe more than once, but one time strikes me. I asked the judge, and the judge gave a jury instruction that said the defense subpoenaed, Joe Dokes. Joe Dokes exercised his constitutional right not to testify. The prosecution had the ability to give him immunity and chose not to. And therefore, even though he's a witness, was at the scene, was precipient, and has cooperated in the past with the prosecution, you should give that the weight to which you find it appropriate. Yeah. In this case, there is an argument that you can make. This guy has gone out and done interviews. He's gone out and done all kinds of other cooperated interviews, not just with the media, but with the cops. And there is an argument that you could make that he has waived it. I don't think that that's the better argument, because I don't think you could waive it in advance, not knowing where the defense was headed in this case. So I would be yelling bloody murder, number one, that the judge needs to give him immunity so that he can testify. And number two, and then somebody asked a good question. If the state gives him immunity, does that cover him for the feds? No, it doesn't. So you could even, if the witness's lawyer could say, give me all the immunity you want, I'm still not going to testify because we know there's a federal grand jury and he's not going to expose himself to the federal grand jury. Does Chauvin's attorney have grounds for mistrial if he's found guilty, and then his grounds for mistrial is the number one witness in this case never said a word? How can this be a trial? How can this be an effective trial if this person never said a word?
If the mistrial motion would presumably be made prior to it going to the jury, but if he gets convicted, he will do that generally. That is done in the context of a motion for new trial to say, hey, judge, you watch this trial. We had every expectation that this witness would testify. We fashioned our defense based on that. And now all of a sudden the prosecution is game playing or playing gamesmanship and not giving immunity to somebody that they interviewed. I've had that happen. I'm in the midst of that right now, where the prosecution flew a witness in to the country. The witness was not available to me to subpoena because he was outside of the country. They interviewed him for 2 days. They didn't like what he said. They let him out of the country again, and then they threatened him with prosecution so that I can't bring him back. That's welcome to America 2021. That's basically what's happened here.
So they had a medical expert for the prosecution come on and say that drugs didn't cause it or couldn't have caused it. There's also an interesting camera angle I think you guys spoke about with the knee more on the back than on the neck, not one that we've seen before. I don't know what happened to the medical expert during cross, but Gary,
you're talking about
because you rarely see it. It's buried usually, if it's in an article, it's usually buried below. I will tell you, Gary, if I'm not mistaken, even though this expert claims to not being paid, which, by the way, I'd love to explain to jurors that experts who volunteer themselves actually have more of an axe to grind than those who get paid. Because, it's the same thing as jurors who claim, I really want to serve on a jury. Cut me some slack. But this so-called expert, I do not believe, participated in the autopsy. He also has made a number of opinions and made a number of statements that I'm telling you, if the defense had brought this person in to make these kinds of statements, the most judges would never let it in. It's completely what we call junk science. Whether the toe was touching the pavement, how much pressure that made, those are not subject to expert opinions, peer review, or anything else. It's really literally junk science.
Well, Gary has some.
Yeah, Mark's referencing a expert we talked about yesterday on Beyond a Reasonable Doubt. I think what Adam's referring to is Dr. Lindsay Thomas, who's a forensics expert that testified this morning, and I'll tell you a little bit more about that after
noon. Well, not after noon on your clock. Noon, 2 U's and an N. Noon Sport. Noon Sport makes your water work harder. It's hydration. You can feel optimized for hydration and mineral replenishment before, during, and after workouts. Just drop a couple of fizzy tablets into your water bottle to supplement your hydration anytime, anywhere. I always take it with me when I go on the road. It's always good, especially after Mark and I hook up in Florida for a couple of Don Julios. Only 1 gram of sugar and clean ingredients that are certified non-GMO, gluten-free, and vegan. 13 delicious flavors, including fan-favorite cherry limeade, which has an extra boost of caffeine, especially good if you're getting into the workout. You get the hydration you need and hit your goals. Visit noonlife.com. That's NUUN for 20% off your first order. All right, Gary, what were you saying?
Right. So Dr. Lindsay Thomas
Gary, clean us up, Gary.
Yeah. So Dr. Lindsay Thomas is who Adam was referring to. She's a forensic expert that ruled that the death of George Floyd was caused by police action. She testified on Friday morning, and on cross-examination, Chauvin's attorney, Mr. Nelson, asked her if the drug overdose could have been the cause of death, and she agreed that absent knowing the full circumstances, drugs could have caused it. She also said that the prone position that George Floyd was in was not dangerous, but when she was examined on redirect, she reiterated her position that the police action was the cause of death.
Yeah, let me explain one more time, because we've seen this is, I think, Gary, third, fourth witness who's done this.
At least.
They report what is the direct exam when the prosecutor's asking questions. That becomes the headline of the story and of the reporting. Then when you get into the cross, you see that there is a completely contrary position that the witness will admit is reasonable. And then they flip-flop again when you get to direct. Why is this important? Because the definition of reasonable doubt is, are there two reasonable interpretations? One pointing towards guilt, one pointing towards innocent. They don't have to be as reasonable, just reasonable. One can be, the prosecution theory can be more reasonable. The defense theory can be less reasonable. But if you have a reasonable interpretation, you must adopt the one that points towards innocence. And you would think nobody has ever heard of the concept of reasonable doubt in the reporting on this case.
All right. Shall we switch subjects and go to the Weinstein appeal or the Deshaun Watson case? Is there?
Let's go to Weinstein because maybe we break a little news. My understanding, and I won't say where my sources are, but my understanding is it has been reported that he's filed the appeal in New York. That is, and it was very lengthy, and he raises some pretty good juror misconduct issues. It's got some legs. If it was anybody but Harvey Weinstein, then you would say that he's got a fighting chance. The news part of that is that it's my understanding that the LA DA's office now is actively moving to extradite him this month to Los Angeles to stand trial on the charges that they coincidentally announced on the day of jury selection in New York. So that is a little bit of news, and we may end up having reasonable doubt and beyond reasonable doubt for a couple of weeks if that ends up happening in the next 2 weeks. But that's my understanding, is the DA's office is not going to wait. They're not going to defer this. COVID be damned, courts be damned. We're bringing Harvey Weinstein here now to try him in LA, even though he's already been sentenced to 23 years in New York.
Is he
What do you
staying
think of that?
in a traditional federal prison? I mean,
No, he's in a state prison, New York State prison now. And if he's brought here, he'll be placed somewhere in the LA County jail system. My guess would be what they call the K-10 area, or they may put him out in Wayside Max or something like that, or maybe Twin Towers. But that would be something. We would leave the Chauvin trial and move right into the Weinstein trial.
He's currently in a facility east of Buffalo and about 40 minutes from Niagara Falls.
God, the Twin Towers, that would be insane because he could probably look out his window and see some of the restaurants he used to eat at. I mean, that's right. That's right in downtown, right?
Yeah, it's right in downtown. It's kind of right on Boucher Street, right around the corner from the old Maine County Jail. And the idea, this goes back to kind of our long running argument about prosecutors having budgets. My feeling is, if I'm a DA, if I'm the LA County DA, why am I bringing him out here on a case where he's already been sentenced to 23 years? He's being housed in the state of New York, and it's going to require a Herculean cost and effort to get him to LA. Why not wait for the appeal in New York to run, see whether or not he gets it reversed? If he gets it reversed, I understand your prosecutorial impetus to bring him out here in LA and try him there. But if it doesn't get reversed, I don't say this with any malice, but Harvey Weinstein's not going to last the remainder of his 23-year sentence, even with good time, work time. He's not going to get out. He's never going to see the light of day. What is the point of trying that case, turning that case into the next supersized circus case so that we can sentence him to more time that he's never going to do?
Well, it's not something you would do. It's not a decision you would make if you were running a business. But if you weren't running a business, but you had a never-ending cash source, meaning the taxpayers, then you would do it because you'd like your name attached to that. That's how these decisions
and then,
are made.
But the way you would do it is you would cloak it in, I'm seeking justice. We're seeking justice, because all you have to do is invoke justice, and then any kind of rational thought just evaporates at that point.
When do you think the Chauvin trial is coming home? I mean, when not coming home? When are they going to bring it home?
I think it finishes in April. Well, I think you'll see that, and that it finishes this month. I think they've got some legal skirmishing, as we discussed, to get through, but I think you're going to see a resolution this month.
Do you have
the only hesitation is if there's a hung jury, the judge can send them back. They can say that they're hung, and the judge can send them back to deliberate some more. And he's already indicated he's going to sequester the jury during deliberations. So that's sometimes will increase the likelihood of no hung jury.
Do you have with all your width and breadth of experience, do you have a feeling for the cadence of the trial? Like a builder would see a house going up pretty fast and kind of know when the keys were going to be delivered to the new couple? Like, is this thing moving along quickly? Does it seem to be a good clip?
Yeah, it's at a fairly good clip. For my second guessing of His Honor and some of this evidentiary stuff, he does jump in, and he's increasingly jumping in. And I'm presuming, because we described before, you can't hear what the sidebars are, but I'm presuming he's basically telling them, move it along. This is cumulative. I've already heard this. You're wasting our time. He keeps it going pretty good, and he keeps a good pace going. So I like a judge who keeps the trains running on time once you're in trial. I have a real problem with judges who make the trains run on time when they don't hold the prosecution's feet to the fire. But he's running a fairly tight ship, and he gets a lot of evidence in each day and a lot of witnesses in each day.
So last question, let me circle back to Tinhorn Flats. How did we leave it with the city of Burbank? What's next?
Last thing I said to the judge within the last hour and a half was, I'll see you very soon, because I'm going to file a motion to dissolve the preliminary injunction. I also am going to probably recommend that they sue the city of Burbank under what's called eminent domain. Eminent domain, as some of you may know, or most of you may know, is when the government takes your property. They can't take your property without just compensation. And they have clearly, the government, in this case, city of Burbank, has gone off the deep end and have seized the property. That exceeds their temporary restraining order when they did it. It exceeds what the scope of it. Lucas was not covered by the temporary restraining order, so he's got some constitutional violations he can pursue. And they've now basically taken the property away from these people. That's fine. You're going to write city of Burbank, you're going to write a large check.
Does the judge have the power to say, this seems like all nonsense to me, I'll just dismiss it or have it go away?
I will not characterize the reaction today, but yes, the judge on a motion to dissolve could give a judicial proclamation that, yes, you guys have exceeded what I ordered, and this is a problem, and I'm going to dissolve it. That's where we're headed.
Wow.
In my opinion.
I am rarely surprised by anything the city does in terms of overreach or aggression, but that SWAT team heading out to Tinhorn Flats, it's getting a little dystopian, I think is the word I would use.
And the fact that you thought I was joking, and a number of people thought that I was photoshopping pictures from Portland, Oregon, I think gives you the complete spectrum of how ridiculous this is.
Absolutely. All right. I am going to be out in Appleton, Wisconsin, Skyline Comedy Club. That'll be May 7th and 8th, and then June 18th, 19th, Golden, Colorado at the Buffalo Rose, and then Anchorage, July 3rd as well.
Wait a second. Aren't you in Nashville this week?
Yeah, I am in Nashville, and I am in Florida, but the Nashville show is sold out. I think you guys can look and see if there's any tickets left.
I have a question, because my son, who may be writing with you to Nashville. Very much wants to get in. You can pull some strings there on that.
We'll get him in. We'll get a little Don Julio in him, and we'll give him some cheesy pretzel sticks.
Pretzel bread.
Backstage. Go to AdamCarolla.com for all the live shows. What do you got, Mark?
Well, look, I'm here in New York right now. Prova in GCT is open. Stop by. Prova and Moxie Hotel in Times Square is open, and they've got some great new slices. Capri will be open in 2 weeks in Southampton. V Palm Springs is, when I was down there, I had people who were telling me that it's actually more happening than Las Vegas. They'd been in Vegas, they've been to the V, they chose the V. So stop by the V, Casa Tropicana in San Clemente, and if you want to do your contribute to a little jujitsu with the mentally ill, come downtown to Engine Company 28, or come around the corner and see the preacher preaching in front of Tenny Mediterranean Tapas.
And also, do not forget Beyond a Reasonable Doubt coming Tuesday and Thursday as well, or Tuesdays and Thursdays as well. Till next time, Adam Carolla for Mark Garriga saying mahalo.
Thanks for listening to Reasonable Doubt. Tune in next Saturday for an all-new episode.